Hello. Today in our video update from Buchler Phillips, we're talking with our own team member, Professor David Fordham, about the new moratorium.
Hi there.
So David, can you make the moratorium sound interesting?
No.
Amusing?
No.
Sexy?
Definitely not, no.
Well, useful then.
Yes, I can certainly say that. The moratorium is definitely going to be useful for companies and company directors as we come out of lockdown in these exceptional times.
So what is a moratorium?
Well, under the new Governance and Insolvency Act, the government has brought into this new process a moratorium that we now have. And this basically freezes the situation for a company which is in financial difficulties and whose directors just need a bit of time and space to try and work things out.
What kind of difficulties are we talking about?
An example might be where creditors are pushing and threatening litigation for overdue payments, or maybe the company's landlord has been threatening to forfeit the lease, although at the moment that's been suspended by the government, or maybe its bank is threatening to enforce a floating charge against the company.
And how does the moratorium help?
It gives the directors time. Initially, that's a month to explore restructuring or maybe even refinancing opportunities for the company. It freezes action. So, except in certain circumstances, no insolvency proceedings can be instigated against the company during the moratorium period. No floating charges can be crystallized. Maybe under a contract, lenders would have had the power to stop the company selling assets. That stopped as well. It actually prevents legal action, save, of course, for employment matters being taken against the company without the permission of the court. And this is very useful. I could continue actually on that theme a little more. During the moratorium, there are also restrictions on the company paying off pre-moratorium debts, granting security, or disposing of company property. But interestingly, if I may say interestingly, the company can continue to pay its rent, and it can also agree to purchase new goods and services during the period.
Well, that sounds pretty comprehensive. How do directors get a moratorium then?
Oh, it's very straightforward. The company directors, or the partners in a limited partnership, simply take the decision or pass the resolution to do it and file the papers with the court. Now, the company, or the LLP, does, however, have to appoint a monitor to oversee the process.
What exactly is a monitor?
The moratorium has to be managed by a monitor, and a monitor has to be a licensed insolvency practitioner, as we have in Buchler Phillips, for instance. And basically, a monitor is a licensed official approved by the Insolvency Service to oversee this process.
What does the monitor do? What's the scope of what they do?
Well, he or she checks that the company or the LLP has correctly gone into a moratorium, but apart from just making sure the papers are filed correctly and the right papers are filed correctly, the monitor has to check that the company isn't hopelessly insolvent and that it does have a realistic prospect of surviving as a going concern. Now, this normally is done by the moratorium starts, and the monitor talks with the directors or the partners to work out what the underlying situation is. Then at the other end, the monitor brings the moratorium to an end.
And how is that done?
Okay, well, let's be positive. The creditors have been notified of the moratorium, they've been advised of the plan, and let's say it's a refinancing or restructuring, and the creditors find favour with that plan. In those circumstances, the monitor decides that the objective of rescuing the company as a going concern has been or can be achieved, and the moratorium comes to an end, probably by a fluxion of time at the end of the initial month, or longer if the creditors give that consent.
What if sadly things don't work out as planned and recovery isn't possible?
Yes, well, it's a pause, it's a freeze, it's not a cancellation of debts. So if the monitor no longer thinks that the company can be rescued as a going concern, or if it's unable to pay its debts, the monitor has to end the moratorium.
What might happen in that scenario?
the partners or the directors have to fall back on the usual options. They could seek a voluntary agreement with their creditors, something that we're seeing a lot of at Buchler Phillips at the moment, or they could seek to appoint an administrator in an administration, or if it's best all round and for the protection of the directors and partners, perhaps even a liquidation.
Understood. But this new moratorium at least freezes everything before then, so the directors or LLP partners can at least have some breathing space, exploring their options and engaging with their creditors and maybe even with their bankers to find a new way forward.
Exactly so, Stephen.
Thanks very much, David. And you said it wasn't interesting. So we hope you found that very useful, learning a bit more about the new moratorium. We'll be bringing out some more videos and webinars in the coming weeks on a range of topics related to small businesses in the current environment. But in the meantime, please be sure to stay in touch with us. Our contact details are coming up now, and we'd be delighted to hear from you to chat about anything at all related to your business. Thanks very much and speak to you soon.